Today on Hashtag Lawyer, we're going to talk about America's frontline doctors and their lawsuit trying to prevent the further use of the COVID-19 vaccination. We're going to go into the science of it, some of the communication, informed consent rights, and really talk about what everybody really needs to pay attention to as this lawsuit progresses forward. Welcome back to Hashtag Lawyer, everybody. We're going to talk about COVID today, which I think we've done a decent job of kind of going away from that topic, not intentionally, but just because there's so many other things that
there's so many other things. And I think we've done a good job for the most part of when we do address COVID, it's something that's very grounded in a legal position. Like I remember one of our earlier episodes was on the restrictions for travel back when we were all in lockdown and how that has effects in the Privileges and Immunities Clause, 14th Amendment, so on and so forth. Is that constitutional? Is that not? Can Hawaii actually ban you from coming unless you get a negative COVID test? Fun fact, yes. Might be a Supreme Court question.
I was going to say, for now they can. It'll
probably be a Supreme Court question if it ever goes up, but I think it would probably be upheld.
And it depends on how some of these things, like what we're going to talk about today, shake out. And actually one of the things that we talked about in closing argument in this episode is about the recent battle down in Florida between Norwegian Cruise Lines and Rick DeSantis. He, he issued or signed into law something that banned the use of vaccine passports, and now that fight's going on.
And we have that here in Texas. And so that's really wild because in direct violation of Governor Abbott's executive order, you have DISD requiring masks for school children.
Right.
So I'm curious to see how that shakes out. That'll be a battle.
And I think that's part of the reason we needed to talk about this specific lawsuit that's going on right now, because we're about to see a flurry of this stuff.
We are. And I think we're going to see so many iterations of this in our home state here.
Yeah, I think so. Especially because we are, our governor has taken a stance like like Governor DeSantis down in Florida, anti-mask, anti-vaccination proof, all that kind of stuff.
Absolutely.
I do think, and you already hinted at this, that the only way this is going to eventually get resolved is because we're going to get conflicting things in different states.
Absolutely.
We're going to have to see the Supreme Court of the United States make some decisions.
I think so. And I think it'll be really interesting, right? Because this is, it's a novel virus, it's a pandemic.
Right.
And so I'll be very curious to see if these cases are somehow fast-tracked, if you will, to the Supreme Court because of the public health emergency. Because normally, as you and I well know, for an issue to get from the trial court all the way up to the Supreme Court, and that takes an awful lot of time. And it usually lags 10, 20 years behind the actual issue.
You can, or even on a small scale, 3 or 4 years, because of how often the Supreme Court holds session and all that. But you're right. The one thing the Supreme Court, which is the way it should be, they're allowed to do some things sometimes to allow things to fast track up because of the nature of the situation and how it's having an immediate impact on what's going on in our country.
Absolutely. And also I think depends too on the way that the original pleadings in the trial court are pled, if they're clever enough to plead them in such a way as to fast track them to the Supreme Court. And if both the trial court and the appellate court want to play ball and they are like, hey, I don't want to issue a ruling here that's going to get me in trouble or me overturned or have, myself given a bad record. And so sometimes they can rule in such a way to fast track it upstairs to the big guys.
Right. And that's, one of the things about this specific suits, they're using an injunction, which is one way that you could potentially try and fast track that up. And we're going to get into the details of what that means and everything. But
let's take it away.
Well, let's just jump right in and talk first about what is America's Frontline Doctors. AFLDS is the acronym. I'm not going to call it that because that takes too much to say.
Yeah, well, it makes me think of either aphids, which are bugs, or LDS, which is the Church of Latter-day Saints or Latter Day. So I'm like, okay, that's definitely neither of those things.
It's probably not close to either one of those.
No,
actually.
I don't think so.
But one thing, just before we get started too, this injunction and the fight in this lawsuit, we're not going to shy away from the fact that it's politically charged, just like this issue has completely become. And I think a lot of people. One thing that annoys it's not the right word because I'm not annoyed by it, but I think one thing I wish people would understand is that there's science behind both sides of this issue. The science is going to be slanted on both sides because that's what you do when you make an argument. And so,
of course,
just like the ACLU, just like the NRA, all these are politically charged entities, but they fund lawsuits, they fight causes through the legal system that promote what they stand for, which just because something's politically charged and that's the kind of crux behind the lawsuit, doesn't mean that the issues aren't actually out there and need to be debated.
Absolutely. And I think, too, kind of one of the overarching messages that we can pull from this situation, right? And you said that there's science on both sides. I think, too, when it comes to vaccines, when it comes to COVID, when it comes to most issues in general, not all, but most, I think if you take a step back, try to have an open mind and really think about, okay, well, why does this side feel X? Why does this side feel Y? Typically, not always, but typically, there's usually at least a few reasonable, somewhat well thought out points on both sides.
Right.
You know, it's very rarely black and white.
It shouldn't mean, say it shouldn't be. You're right. It's very rarely that way. It's also very rare that you see people on two sides of the issue, especially this issue, willing to consider why the other side thinks the way they think. But we'll get into some of that stuff here.
But our audience should, because they're clever.
Right. Well, that's the whole point of this podcast.
Yes.
Right. So America's Frontline Doctors, they're a politically motivated group. Their website lists that they're a not-for-profit organization. They claim nonpartisanship. I don't know that a such thing exists in our country about nonpartisanship, which again, I'm okay with. That's the whole political system we have. Their mission statement, we'll have this put up on the podcast. We'll have Matt insert this here so we don't have to go through everything. But this group was largely founded during the beginning of the pandemic on the issue of trying to expose, in their minds, some of the fallacies with the COVID-19 information. And then now it's moved itself over to the vaccine side because that's where the biggest fight is going on here. And of course, a lot of people, and the thing is, I grabbed a lot of some of this background information from critics of the organization, just because I think it helps everybody understand why there's maybe some negative connotations with this organization. The founder, Simone Gold, is a doctor. She's been on the front line, including even being arrested for her participation in the Capitol Hill riots.
Yes, so, now that's interesting.
Yeah, controversial figure. So I will say that's a lot of the opponents or critics of this organization. They keep pointing at that and saying, well, look, if she's the one that's involved, then this has to be a crock. So, okay, again. Yeah,
really smart people can make mistakes.
Well, and again, you heard my opinion about what people were doing on Capitol Hill and the riots and how ridiculous I thought that was. It doesn't make sense to me to say, okay, because of this, then you can't, it's a logical fallacy.
I would agree with that. They're two separate things.
Yeah. So there's a lot, and you guys, I encourage you, go online. You can see a lot of negative press about this entity, and then you can see a lot of really staunch supporters of the entity, just like any other politically charged. It just depends on what source you're looking at when you read through it. So they filed for a preliminary injunction, as they call it in the federal system. And so this is a prime opportunity, like you and I love to do, to talk about what an injunction actually is.
Yes.
How do we use it in Texas? All of those types of things. Yeah. And so in Texas, we've got
a TRO.
Yes.
I love a good TRO.
Yes, I know. I figured I was going to let you tee this one
I'm
off
like the queen of TROs. I just went down and got another one not too long ago.
Like a hobby. Yeah.
Yeah, it's pretty much a hobby on my end. No, I'm kidding. Don't tell the courts that.
That's probably the most boring hobby in the world. But.
Yeah, they can get pretty intense. Okay, anyway, but so a TRO is a temporary restraining order. And so basically it allows an individual to go to the court and seek the court to restrain some sort of activity that an individual is, or even an entity, right, is seeking to do. So for example, you have Michael. Michael is part of a restaurant group, and Michael is just credit card happy with the restaurant card. And he, takes clients out to dinner every single night and spends $5,000 on dinner, and he's draining the company funds. And at that point, employees can't be paid.
Yeah.
So then the rest of the owners in the restaurant group go to court and they say, court, we want you to issue an injunction against Michael from spending all this stuff on the company credit card with these limited exceptions that we've approved that are clearly company-related expenses.
Yeah.
That's a very clear example of typically a situation where a temporary restraining order would most likely, but not always, be issued in that situation.
And there's usually an emergency like you're talking about.
There is, yes. There has to be.
Michael's running it, and so...
And there actually has to be an emergency. There has to be what's the magic words are imminent irreparable harm.
Right.
And so now the flip side, right, this can only last 2 weeks.
Right.
By law. Now, there are rare exceptions where you can extend it.
Yep.
But it typically only lasts 2 weeks. And then you, at that point, have to have a temporary injunction hearing or a TI hearing, right?
Yeah.
At ideally the end of the TRO period. But these days, with the backlog in the courts, I'm finding that some courts are like, the only time I can get it in is 8 days out of the 14.
Yeah.
So it's now or never.
Right. Right. And this process makes sense because a TRO is usually issued in an emergency situation.
Yes.
You have to have emergent circumstances that justify, okay, yes, we need this order right now.
Right now.
And it's issued sometimes without any kind of discourse back and forth in front of the judge. And then sometimes they're very limited. Well, and I'm thinking about in family law, where in family law, you can get a TRO.
I'm also thinking about in probate. So I've recently gotten a few TROs in probate court. And before that, I had exclusively gotten temporary restraining orders in district court.
Sure.
And
civil court.
civil court for everyone.
Yeah.
And so usually most counties require a 2-hour notice
Right.
to the opposing counsel. I mean, you're supposed to do that in probate court, but I don't know if it's because of COVID-19 or what, but they've granted my last temporary restraining order on submission. I mean, I still, sent the person that I was seeking to restrain a notice of everything. I gave him a day's warning because I was like, look, I'd like to play by the rules. Yeah. Well, he didn't respond. So, I got the TRO. But
well, and that's the interesting thing too, is when you look at like my experience getting restraining orders in civil court, most of the times it's more rare that I've seen them in civil court, but you end up having, some kind of an argument because you give the 2 hours notice, the lawyer shows up, you have a discussion. Family court, 9 out of 10 times, nobody gets notice. One side goes and gets the TRO. And it makes sense because there's kids involved. There's something going on where you need to immediately get something restrained. And so the courts are more likely in family court, at least here in Dallas, Collin, Denton County, to issue TROs, what we call ex parte, without noticing the other, notifying the other side.
Yeah, so the Latin for like from the party, essentially. And so you're able to do that because if there's an extreme emergency and someone's going to be harmed or it's really, really bad situation.
Right.
So,
and it makes sense that there's this temporary injunction hearing, which is like a mini trial.
It is. It is
makes
a mini
sense
trial.
Because of the TRO, there's not a whole lot of argument evidence on the front end. And so the courts only wants to allow that to stand for 2 weeks so that we can sit down and say, all right, let's put all this on the table. Let's actually have a discussion here and get the evidence out and let the court make a decision on this.
I mean, there's witnesses, there's exhibits. I mean, the whole 9 yards.
Yeah. And the interesting thing too about it that we need to make sure everybody understands is that a temporary injunction, or in the federal system, which we're talking about here, a preliminary injunction, that doesn't end the case.
No, it does not.
Right.
It typically only lasts during the pendency of the case, right? So as long as the case is operating until there's a final judgment issued in that case, which can be a while. Some cases take 2 years to resolve.
Right, exactly. So here, the Frontline Doctors, they have filed seeking a preliminary injunction to stop the use of vaccines for minors, those who have been previously infected with the virus, and what we're going to call compliance with Section E of these regulations, which we'll get into in a second, which primarily deal with informed consent, or giving the information on both sides of the risk and benefits of the vaccine to healthcare providers and to the ultimate patients that are receiving this. And so those are the three big grounds. The statute that we're dealing with here, federal statutes are always so long, so I'm not even going to really read it. I mean, I'll cite the initial
Yeah, I was about to say, go ahead and give the cite.
Yeah, it's Title 21 of the Food and Drugs Act, and it's Section 360 BBB-3.
Okay, so for all of you who are maybe secret law nerds like us, or at least me, okay, Harvey Specter, you can go look it up and read it.
That's what we're operating in, and this section, paraphrased, it governs when the Secretary of the FDA can issue a product for emergency use that hasn't gone through the FDA testing procedures.
And so emergency use should be ringing a lot of bells.
Yes.
Because that's exactly what the vaccines are, emergency use issue.
Right. Well, and that's the center of the argument, is whether or not this actually is an emergency, whether or not they've met their burden, or whether or not the Secretary had the authority. And that's kind of the basis of the injunction. So,
but that's how these vaccines have been billed to the public.
Yes. Well, and that's you're right. That's the whole way that they got into use here, is because of the emergency. You're exactly right. And so there's a 67-page preliminary injunction petition that I read through and made notes on. To summarize it down.
Wow, look at you. You are a secret law nerd.
It was interesting. It's a very hot topic, and there's a lot of things that went into it. And I will tell you personally, for me, we see this debate of public in the court of public opinion over this issue. We've seen it for over a year now. And you and I have talked about this before. It's insanely frustrating for us as lawyers to watch that go back and forth. Yeah. Because no matter which side I agree with, every time I see a statement, I'm like, well, where did you figure that information out? Where did that come from?
Where is your source?
Yeah. And some people I talk to, that drives them crazy because of my cynicism when it comes to that. But this is what I loved about this petition, why it was so interesting, is that we finally have a concise argument put into a brief that where you have to cite 2 sources and you have to make an argument based on sources and facts with footnotes and all that kind of stuff.
With actual evidence.
With actual evidence. And so we get to actually finally see, okay, now we're seeing something that's actually going to be tested in court, which is the entire foundation of our legal system.
And one of the things I really like about this situation is this is not just, war of the words on Facebook or Instagram comments.
Right.
You actually have, like you said, real sources.
Yes.
And so I think that is refreshing.
Big time. That was why I was excited for it. And just big picture wise, this was filed on July 19th. Of this year. Not all the defendants have been served yet. So the court has issued an order saying we're not going to rule on this until all the defendants have been served. And of course, what happens at that point, they get to file responses.
Yes.
So that's where we get to see this competing. We get to see the science compete against one another. And it sounds silly that I'm getting excited about this, but it's like, this is what we've needed for a long time. Because when you have whomever on Instagram or Facebook fighting whomever on Instagram or Facebook, okay, guys, I mean, sure, have your opinions, but you're saying that what the things that they're basing their facts on are false. You're saying the same thing. So, okay, let's vet this out now with actual battle of experts, and let's have a hearing on it
with actual qualified individuals. Because I always find it interesting when people devolve into name calling and comments about like fascism and this and that, and I look at them and they're like an Instagram model or a chef.
Yeah.
I'm like, okay, well, you're not a virologist.
Right.
So, I mean, I'm not saying you're necessarily uneducated, but I would probably have a more respect for your arguments if you like cited sources.
Yeah.
Like maybe a medical journal or something.
Right. Which is part of what I loved about the brief is we have cites to medical journals, we have cites to actual statistics, all that kind of stuff. And studies
which is fabulous.
And that's what we need. That's what we need. So to paraphrase the challenges that they're putting together, there's really 2 kind of categories. There's scientific challenges that are based on kind of what I was just talking about, the scientific facts, all that kind of stuff. And then they're informed consent challenges, saying that the public and the doctors have not been fully informed about the risk and benefits which are required under the act here. And so, again, I'm trying to paraphrase this a little bit so we don't get lost in the weeds
in the detail
of federal regulatory law. But
as someone who took admin law, let me tell you, it's easy to do.
Right. Well, and you've got a better grasp of this even than I do, or probably our listeners do, because of being in admin law like that. But
working at the Texas Railroad Commission, you get to see admin law up close and personal.
Sure. So, under the scientific grounds, they've challenged it because first they've challenged whether or not the state that we're in is actually a state of emergency as required under the statute. Second, whether the vaccine is proven to actually diagnose, treat, or prevent COVID. Third, whether the benefits actually outweigh the risks. And so those are the 3 big categories. As a prerequisite for all this, the secretary can only allow this product to be used if there is a state of emergency. So a lot of the citations here have to do with the survival, or excuse me, a lot of the science that they bring in here has to do with the survival rate of people who contract the disease, the amount of people that that actually got it compared to the population. And these are the types of numbers that we've heard, at least I've heard when I've read things about it, have been all over the map. You've got some people that say it's XY, some people that say it's,
Yeah, absolutely. So, I mean, I've heard differing opinions even amongst doctors in terms of because I prefer to talk to my friends or read articles where doctors are quoted.
Yes.
Because I feel like they're a bit better than, say, your local Instagram model at actually reviewing journals and reviewing data and making their arguments based on actual data that's been compiled. And even amongst them, there's a wide difference in terms of articulating or estimating, the number of deaths resulting from COVID. I mean, the way that COVID deaths are counted in different countries, like say countries in Europe, apparently, according to some doctors, that's different than the way that we count deaths here in the United States, And so there's quite the variance between the 2.
Yeah. And that's the perfect example of, because some people I think have the opinion that, okay, well, science is science, math is math, numbers are numbers.
Not necessarily.
And that's why we have expert witnesses that can have different opinions like what you're talking about, which is why we need these kinds of debates to happen in a controlled environment.
In a controlled environment where there's not going to be name calling.
Right.
Yeah.
Right. You can object to the name calling.
You can object to the name calling. You can say, can we get back to the evidence, please? Which is what I love.
Yeah. And I think going a little deeper into what you were saying a second ago, part of the reason that we have make sure I get this right. Rule 702, I believe it is in
702 and
Texas.
703. Oh, I'm sorry. I was thinking the federal rules of evidence.
Maybe it may be the same rule, but basically,
it probably is.
We have to qualify our experts.
Yes.
You can't just come up on the stand and talk about something and give based on my expert opinion. This is what. So we have to qualify it so that you don't have the person who really doesn't have the background or the knowledge or the right's the wrong term, or the credibility to be discussing reliability of vaccine numbers and what it does and all that kind of stuff.
And I think it's really important for our listeners to understand it's very specific. The type of professional, right, or type of expert that you're trying to prove up, they're qualified through training, skill, knowledge, and then they also have to provide actual expert reports,
right.
Articulating their opinion, showing the precise methodology that they engage in their opinion, that the method is either, widely accepted by at least a recognized minority of experts in their field. Or if it's not, then it's like every step is articulated to show the court, oh no, maybe I have a unique method, but it is reliable. Right. It's testable. It's fine. And so, oftentimes experts are the subject of what are called in federal court Daubert challenges, Robinson challenges it is Robinson, right? Not Kelly. Yeah, Robinson in Texas civil court. And there's a lot of money spent fighting about experts. And so for an expert to get into court and testify, they've gone through a pretty rigorous process to get in.
And the good thing is that, and some people don't like this idea, but the expert on the other side can take that report and try to dissect it. But that's what we want. We want these two experts.
Yeah, that's what they always do.
Right. That's what I'm saying. We want them to battle back and forth.
Yes, we do.
So we can try to figure out, okay, what's the most credible form of the argument here?
Because by the time they're battling back and forth, typically at a final hearing, right, they've been qualified.
Yeah.
So these are both qualified experts that have different opinions based on similar evidence.
Right. Right.
That's what I want.
And that's what we're going to see here, because there's things they challenge on the methodology of the PCR testing, whether or not it's reliable and whether or not it actually can prove what the state of emergency says that it has to prove. And then there's also this attacks of this concept of the asymptomatic transmission, the idea that people who are asymptomatic can actually transmit the disease to a pandemic level. There's competing views on that in the medical world, in the science world there. And so that's kind of the first section of the science portion. One thing that's interesting to note about this statute, I wanted to make sure I listed this out, is that in order for the secretary to issue and allow a product to come out and be treated in an emergency way, they use a cumulative way that they drafted the statute. So it's not just that okay, yes, there's an emergency. Okay, yeah, we can issue this. Or, well, the vaccine actually does treat. Then we can issue this. It actually there has to be an emergency, and there has to be evidence that this vaccine can actually treat the disease, and the benefits have to outweigh the risks. And so it's a cumulative thing. Whereas we know when we look at statutes when they're drafted, if you knock one of those out, well, then all of a sudden you can't. You don't meet the elements of a cause of action, or you then can't issue the product out.
Yeah, it's definitely an addition, not a pick one.
Exactly. And that makes a big difference whenever you're going through and analyzing these types of things.
And I think that the phrase like treating the disease is interesting, right? Because even then that can be up for a scientific debate, right? Because just treating the disease, does that mean preventing the individual from actually contracting COVID-19? Or does it just simply mean, well, they can still contract it, but it prevents them from being at such a severe level as to require hospitalization or putting them at risk of death?
Or does it treat just the symptoms?
Or does it treat just the symptoms? Yeah. So what is treatment?
Right.
Can you define it for me?
And that would be helpful to have people who, unlike you and I, actually know what this stuff means and how to go and look at it.
Yeah, I'm no medical doctor. Yeah. I'm just a lawyer.
Yeah. And I think that's one thing I'll say is a kind of a personal side note. I think that's one of the things that you and I agree on, is that we trust. The reason we have expert witnesses is because they know what they're talking about. And so I trust them to come in and talk about what they're talking about. Yeah. I just argue the facts they give me. And so it's easier for me to rely on them and what they're saying if they've been vetted and if, all those types of things. So, and I won't beat this thing to, I won't say to death, but I guess.
I think the phrase you're looking for is "I won't beat a dead horse," which I hate that phrase.
Yeah,
that's really gross.
That's why I didn't say that one either.
Yeah.
But they talk about, everybody's heard a lot of the arguments that are made in here. There's talks about the, on the risk versus benefits piece, there's talks about that the vaccine adverse event reporting system, the VAERS reporting system, has shown that there's been an increase in vaccine-related deaths. And here, this quoted and cited to is about 21,000% increase in the first quarter of 2021 versus comparative quarters. There's numbers in here about the deaths that have come from the COVID vaccine that have been reported to VAERS. And so that's going to open the debate for, okay, let's look at the science, let's look at the battle of the experts here and figure out what these numbers actually look like.
And I think there will also be I'm sure there will be another expert on the other side once all the defendants are served that will attack the VAERS system, because I'm sure they'll be attacking not necessarily the integrity of the VAERS system, but if I understand it correctly, I mean, these are people who are self-reporting. And so if that is the case, which I think is correct, then I'm sure there'll be an expert, who is an expert in self-reporting systems and how often is there going to be user error, if you will, and are these estimates overblown, are they not? So I'm sure there will be an expert that will be opining on that.
Well, and actually that brings up a good point, because we've heard the debate for a long time about, okay, well, a lot of these deaths that occur due to COVID, they're classifying every single thing that could potentially fall under the umbrella as COVID. So maybe those are inflated. We're also hearing the debate of what you were just talking about, that maybe there's an inflation on the amount of deaths reported due to the vaccine, and maybe there's an under-inflation. There's actually an argument put in here with one of their fraud analysts that comes in that talks about comparing the Medicaid, Medicare reporting system. And I think actually, now that I'm thinking about it, I think the VAERS database is reported by physicians who someone comes back in. Because I think that what I remember reading now, it was 67 pages. But I think there's also a self-reporting system called like the VIP app or something like that, where people are self-reporting, and those numbers naturally are not going to be the same as the providers that are reporting it. Either way, there's going to be arguments on underreported, overreported, underreported, overreported.
And there will certainly be experts on each of those issues.
Right. So the second big portion of this, I said, was the informed consent piece. And this is the piece that I think, to me, this is the more legal procedural aspect of the lawsuit. That the other part is the battle of science. The experts are going to have to vet that out. Over here, the idea is that under the statute, it's required that the healthcare providers are given enough information to know of the potential risks and benefits of the emergency use of the product, and the extent to which the benefits and risks are unknown of the product. Now, and the alternatives that are potentially available. That's the other piece. The interesting thing about that is I'm sure the healthcare providers are given a lot more information about this than maybe is passed down to the patients.
I think so. And I'm very much of the opinion that not only are they most likely given more information about this, but they have access to and are aware of professional peer-reviewed journals such as the New England Journal of Medicine, which is an extremely prestigious journal. Right? I might casually read an article in there because my best friend's dad is a doctor, and he has opinions about COVID-19, and he'll tell me something. He's like, well, but go ahead. Why don't you go ahead and read the article? And he'll cite me the article. And so, because he was like, I'll tell you this, but go check it out yourself. And so, he's great. Dr. P is the best. And so doctors at the end of the day are going to have access and are aware of more sources that are going to give them a better, more evidence-based view as to all of these facts. Right? Versus, again, not to hate on Instagram models. I think they're great. Love the influencer community. Love the influencer business model. But again, they're not medical doctors for the most part. And so I don't think that a non-medical doctor influencer is going to think, oh, let me go read a peer-reviewed journal before I take a position on Instagram.
So that's the first piece of it. And the second piece is the same concept with patients, except this is the part they key in on in the brief, is that also under the statute, patients are required to be informed of their right to accept or refuse the administration of the product. And what they're keying in on is that it is the message that's been delivered over the course of this year, basically, and that it's really insinuating and implying and coercing people to feel like they have to get the vaccine because of X, Y, and Z.
Like through all the billboards that you see here in Dallas, through all of the public relations campaigns on Instagram and so forth. Okay.
So it's kind of a constructive, we're forcing these people, they don't understand they can refuse or accept. But so they're keying in on that with this brief, is that it's required that patients be informed of their ability to refuse or accept.
I do find that argument very interesting, right? Because it's not the situation that we're seeing with, like Baylor and perhaps Children's Hospital here in Dallas. I'm not sure, where employees are actually required to get the COVID vaccine or be fired.
I know there's I think in Houston, the Methodist Hospital.
That was the big one.
Which
that was
a private hospital, a little different situation.
A different situation, But so I found that interesting that they're not tapping on that, but rather they're tapping on the situation of, well, there's this big kind of public relations campaign for people to get the vaccine, which it's interesting because I don't think any provider is going to say, well, because of the public relations campaign, you have to get a vaccine.
Right.
Now they can strongly urge you, but they can't give you a treatment without your consent generally.
Yeah.
I mean, there are of course exceptions, like if you're bleeding out on the table and you don't have a DNR.
Yeah. Well, and what they key in a lot on the brief is that the message is coming from the top. Obviously, President Biden has been very adamant about what he wants the entire country to do about getting the vaccine. And so I think that is one of the key things they're saying, that it's this trickle down message from the top, making a lot of people who maybe are not as well educated, not as well informed about everything, feel like they have no choice but to, participate. So again, that part of this is the more procedural, constitutional argument. The science part is the part where the experts are going to really battle it out. And, ultimately for me, we've already kind of said this over and over and belabored it, but, I have a very strong opinion about where I stand on all these things. And I think that even on the side that I stand on, that I'm not going to get the vaccine, and I stand strong on that. I hate whenever the message is projected out there by people who are Instagram influencers who are just throwing it out there without information. And at the same time, I like receiving information that I feel is vetted and I understand it even from the opposing side. And I think that's been a problem too, as we see the press on both sides of the issue doing the same types of things as the Instagram influencers are.
And I just, at the end of the day, I'm vaccinated.
Right.
Yeah. And so so we have different opinions on it, but I mean, we can still have a good engaging civil discourse, even though we have different opinions on the vaccine. I think I'm fairly moderate when it comes to the vaccine, because I had a very different path in terms of determining if I was going to get the vaccine, which talked to a lot of friends who are doctors, Dr. P and all that. But I think at the end of the day, what really bothers both of us is the misinformation about COVID-19 and the vaccine.
Right.
And I think that at the end of the day, we can arrive, and clearly we have arrived at different conclusions about the vaccine, but I think we all agree that at the end of the day, the misinformation is not good.
It's not. And my hope is with this lawsuit, I hope we get to a full-blown evidentiary hearing.
Absolutely.
And get to see, and you know what? People don't have to agree on the outcome, but at least the information that's being put out there has been vetted, it's been filtered, it's been checked and challenged and objected to. And we can actually see, okay, let's get some real numbers on the board here.
Absolutely.
And actually have a conversation, at least based on maybe not the same, but closer to similar information than what's being thrown around in the universe right now.
Absolutely.
So it'll be interesting to see this. And like we said, I think this is only the tip of the iceberg of a flurry of legal battles we're going to see.
I think we're going to see a lot.
All over the place.
A lot of these
in this country, across the world too, but in this country and how this is all going to play out. And really hope that the Supreme Court gets to this issue sooner rather than later. And it'll be interesting to see whether or not maybe the pandemic fades over the next couple of years and then all of a sudden it's not as relevant anymore for the Supreme Court to hear. So I don't know.
Who knows? Maybe it'll be a Roe versus Wade situation.
That's kind of what I'm hoping.
And I think it probably will be.
I think it will too.
So, all right.
Well, y'all stay tuned and keep watching, because there's going to be a lot more of this come up, and keep reading and researching all these things, and definitely follow this case out of the Northern District of Alabama.
You want to give them a cause number?
Cause number, yeah, definitely. So it's 2:21-CV00702.
Thanks, y'all. Hey, y'all, don't go. We have closing arguments coming up for you in just a second. But before you listen, make sure to rate, review, and subscribe to the podcast if you got any value from today's episode. And please share the podcast with others. And if you want to interact with Austin or me, or tell us what you want to hear next, you can find me on Instagram at andrea.s.turner, Austin at The Dallas Lawyer, spelled out, or the podcast, #lawyered, spelled out. Look forward to hearing from you.
Governor Rick DeSantis and the state of Florida have lost the first battle in their fight against the use of vaccine passports as they take on Norwegian cruise lines. The state of Florida implemented a law on July 1 that banned the requirement or use of vaccine passports. Norwegian Cruise Lines, a large company that does a lot of business in Florida, then sued the state, saying that this unconstitutionally infringed on Norwegians' rights and it jeopardized public health. So far, the trial court actually ruled in Norwegians' favor, and now Governor DeSantis vows to appeal this to the 11th Circuit Court of Appeals. This is just one of many legal battles that have started over the debate over whether vaccines are constitutional and whether or not the government can ban the use of vaccine passports. A lot more to come, and we'll be definitely following and keeping track of this as it develops.